Joining us now on the show, we have Adolfo Azcuna Jr., retired Associate Justice of the Supreme Court and a respected constitutional law expert. Magandang umaga. Welcome back to the show. Justice, can you hear us? There you go.
Good morning.
Okay. Justice, the Supreme Court again unanimously upheld its earlier decision on the Duterte impeachment complaint. What was your immediate reaction to that decision? Does the upholding and the voting come as any surprise to you? 13-0, denying with finality the Vice President's impeachment complaint.
Yes, ang ibig sabihin niyan resolusyon ng ating Korte Suprema na pinalabas kahapon ay final na talaga yung kanilang desisyon na binasura yung articles of impeachment na inadopt ng ating lower house noong February 5, 2025. Dahil void daw yun dahil labag sa 1-year ban. Yun po ang kabuuan ng resolution na yan. Ngunit maraming pinaliwanag na dinagdag ang Korte Suprema sa mismong resolusyon na ginawa kahapon.
Kayo po ba ay nagulat dito sa desisyon o inasahan po ninyo?
Hindi naman ako nagulat dahil medyo expected ko na yun na di-deny talaga nila yun. At saka expected ko rin na magpapaliwanag sila sa ilang puntos na dapat liwanagin doon sa desisyon na yon.
So yung main issue po dito, yung naging pag-upo doon sa first 3 complaints bago po ito ini-refer sa Committee on Justice. Tama po ba?
Tama, yun po ang bagong issue na nagdagdag sila ng tinatawag na another way of initiating impeachment proceedings aside from referring it to a committee ay kung uupuan lang daw at lumampas na yung takdang panahon na pag-refer sa committee ay yun ay initiated na rin.
Ibig sabihin ho, nagbabago na ho yung definition ng initiation with this new ruling?
Hindi naman binago yun. Dating definition, dinagdagan lang. Sa Supreme Court decision ngayon, meron ng karagdagan na 2 pang paraan kung paano mag-initiate ng impeachment proceedings. Ang una, yung dati, good pa rin yun. Namely, referring to a committee after receiving the complaint and calendaring it within 10 days, referring it to committee within 3 days. Good pa rin yun. Initiation pa rin yun. Ngunit pag hindi ito ginawa sa takdang panahon 10 plus 3 days at binago nila yung definition ng days na yun, that is calendar days during which Congress is in session, kung pagtanggap ng complaint, lumipas na yung 10 days pag-calendar at 3 days pang-repair na hindi naman kinalandar, hindi rin refer sa committee, ay yun paraan na rin na tinatawag nilang initiating na rin yun. That is the second type of initiation that is added by the Supreme Court in this case. There's a third type pa. Kung kahit na hindi lumampas yung takdang panahon na yun, pero nag-adjourn sila, nag-adjourn na hindi pa rin refer sa committee pa rin, ayun na initiated na rin.
So as a framer of the Constitution, do you think this upholds the spirit of the law?
Ang nasa Constitution kasi nakalagay na oras na merong tinanggap na balido na tamang complaint, ibig sabihin under oath. Tapos kung galing sa isang mamamayan, kailangan endorse ng member ng lower house. O kaya originally verified, filed by a member of the house, yan ang duly filed complaint. Ito dapat within 10 days from the filing, ilagay sa kalendaryo ng plenary. And within 3 days na nalagay sa kalendaryo, i-refer sa Committee on Justice. Ngayon, unang binago ng Supreme Court yung definition ng 10 days at 3 days. Hindi ito session days, kung hindi calendar days during which Congress is in session. So bagong konsepto yan. Pero ganun pa rin, meron po 10 days, 3 days. Kung hindi ito ginawa, hindi kinalendaryo, hindi refer sa committee, at lumampas na yung 10 days at 3 days na yon, ay yung complaint na yon, ibig sabihin na initiated na rin. Ano yun ang nangyari dito? Yung complaint na pinail, tatlo kasing pinail, merong December 12, December 16, December 24. Yung unang pinail, December 2, ay lumampas na yung 10 days, 3 days, hindi refer sa committee. So, sabi ng Supreme Court, na-initiated na yung proceedings by that first complaint. So when Congress adopted its own articles on February 5, 2025, pangalawa na yun. Barred na yun. Sabi na, pang-apat na nga, barred na by the first complaint which was not acted upon within the mandated period.
Pero nabanggit nyo rin ho, doon sa post nyo sa Facebook, that the articles approved by Congress on February 5 last year were not yet barred by the inaction on the 3 earlier complaints because the 10-day deadline has not yet lapsed, according to the House's interpretation of the constitutional time frames. So hindi po kayo agree sa desisyon?
Hindi. Sabi ng Supreme Court, kung sundin mo yung session days, hindi pa nag-lapse. Dahil yung session ng Kamara, ibang konsepto yun. Maaring several calendar days yun eh. Pero sabi ng Supreme Court, hindi dapat yun ang sundin. Dapat sundin yung plain meaning ng day, which is calendar day, during which nagsisesyon sila. So kung yun ang gagamitin, lumampas na yung panahon.
Oo, para pong ito po yung naging usapan ng LTO tsaka ni James Dikin, yung calendar days, working days. Dito, the application is calendar days when Congress is in session or session days. So, medyo napapabilis po yung proseso. And speaking of that, what was your observation about the effect of that ruling to the whole impeachment process? If you take a look at the filings made against the President, dalawa lang ho yung natanggap nila nung unang session day, which was the complaint of lawyer Andre De Jesus and the complaint of the Makabayan Bloc. Okay lang ho ba yun na hindi po nila inantay na lumipas po yung 10 days na diniretso na kaagad po sa Committee on Justice? Hindi na ho nakahabol kung sino man may gusto pa. What is the effect of this ruling on the whole impeachment process as an accountability tool?
Yung ginawa nila, tama po yun dahil within 10 days from receipt on filing of those two complaints against the President, refer nila kinalendaryo tapos refer doon sa Committee on Justice within that 10 days and 3-day period required as interpreted calendar days during which they were in session. So these two complaints which were initialized already together will bar any further complaint.
They have no requirement to let the 10 days pass, at least wait for others who intend to file. Hindi po ba magiging unahan na ho itong filing? Baka parang race against time?
Hindi naman, kahit pwede naman within 10 days from the time yung una na file, hintay nila kung meron pang darating. Pwede pa nilang tanggapin dahil they have 10 days to refer to the committee from the filing of the first one. So if there's a second, third, fourth filed within the 10-day period, maaari nilang isabay yun pag-refer sa committee, yung 3 o 4.
Pero kapag na-refer na ho sa Committee on Justice, hindi na po pwedeng umabol?
Hindi na. Pag meron nang na-refer sa committee, hindi na pwedeng humabol dahil initialized na yun eh. Na kick in na yung 1-year ban.
But doesn't that make opportunity slimmer for others? At least a fair right to be heard kapag ganun ho?
They will have to wait 1 year.
Ano ho?
Yes. They have to wait next year.
Oo, yun nga ho. So, ito hong na mga gusto mag-file pa ng impeachment complaint laban sa Pangulo, what would their recourse be now? I know there are 2 complaints already that have yet to be tackled, but what other recourses do they have? Specifically, ito po kung wari ho, yung grupo nila, Mike Defensor.
Anong recourse ng hindi nakahabol?
Oho, yes ho.
Well, they can participate in the hearing. It's open naman to the citizens. Hearing of the first 2 na na-file. And take part there. Kung they have evidence to present, they can also ask the committee to receive their evidence. Siguro gano'n na lang. Dahil yung mismong complaint nila, hindi na pwedeng i-file yun. Hindi na pwedeng initialize dahil barred na.
Okay. The Supreme Court also ruled that the doctrine of operative fact does not apply in this case. The spokesperson of the Supreme Court said that the operative fact doctrine cannot be invoked by the party directly responsible in the commission of an unconstitutional act. Do you agree with this assessment by the Supreme Court? Kasi ang argument ho ng Kongreso ay sinunod na nila yung Gutierrez versus House of Representatives on the definition of initiation. Ang sinasabi ng Supreme Court, hindi mag-apply yan kasi unconstitutional yung ginawa ninyo. Do you agree with that assessment?
Okay, ang issue doon is itong bagong definition ng Supreme Court ng dinagdagan yung paraan ng pag-initiate ng proceedings. Sabi ng Supreme Court, normally, kung binago yung definition, in this case, may bagong definition, hindi naman binaliwala yung former, pero nagdagdag ngayon ng another way. So, itong panibago, normally, hindi dapat i-apply retroactively sa mga nangyari na hindi pa ginawa itong bagong definition. Yan ang rule of operative facts. Ngunit, sabi ng Supreme Court, hindi i-apply ng rule ng operative facts sa sitwasyon dito dahil yung prinsipyo na yan, maaari lamang gamitin ng isang party na hindi kasagwat sa paggawa ng paglabag ng batas. In other words, Congress cannot invoke it, the lower house cannot invoke it because it is in bad faith. Yun ang sinasabi ng Supreme Court.
And do you agree with that?
I agree with that. That is really the principle. And since Congress deliberately avoided the kicking in of the period by not acting on this complaint, that is bad faith. So, tama yung Supreme Court.
Dahil hindi ho gumalaw, kumbaga parang meron na dyang complaint, hindi mo inasikaso. So, bad faith po.
That is,
But
yes.
Your fellow CONCON delegate, Attorney Rene Sarmiento, called this decision judicial amendment to the Constitution and an overreach. He in fact says that the decision emasculates impeachment as a weapon of accountability as envisioned by the framers of the Constitution. Ano po masasabi po ninyo dito sa naging opinion ni Attorney Rene Sarmiento?
Sa palagay ko, tama rin si Attorney Delegate Rene Sarmiento kasi binago ng Supreme Court, sinabi na nga ng saligang batas session days. Bakit sinabi ng Supreme Court, ibig sabihin yan, calendar days. Panibago na yan. So, but then, the Constitution is what the Supreme Court says it is. So, kaya sundin natin yung definition ng Supreme Court dahil yun ang interpretation nila ng ating saligang batas.
So is there, could the Congress choose not to follow the Supreme Court ruling if they decide to? Because curiously, the Supreme Court also re-emphasizes that Congress is granted the sole prerogative to define the rules on impeachment. So if they choose to do so, pwede ba nilang hindi sundin itong ruling na ito?
Yes, this presents a problem because the Congress, under the Constitution, has the continuing power to frame and adopt rules to implement the impeachment provisions of the Constitution. So, supposing Congress now will adopt a new rule, but it will not follow the new definition of the Supreme Court. So, magkakabanggaan ngayon ang Congress at Supreme Court on the definition of 10 session days. So, ang mangyari niyan babalik naman sa Supreme Court yung bagong kaso, questionin ngayon yung bagong rule ng Congress na kung maaari ba ito nilang baguhin yung definition ng Supreme Court. That will be another issue, another case.
And we might end up in a constitutional crisis if that happens.
Yeah. Yes, that will be another test case because the definitions of the two political and constitutional bodies will be in conflict again.
Well, Justice, what other recourse is there now for those who see judicial overreach? The Supreme Court says there's no more room for appeal. How firm is that declaration?
Sa palagay ko, hindi naman mahirap sundin yung Supreme Court decision dahil maaari namang sundin lang yung Francisco ruling. Yung Francisco ruling, within 10 days, palagay mo na calendar days. Mas mabilis lang konti yan eh. Within 10 calendar days during which they are in session, i-calendar ka agad, ilagay sa calendar ng plenary yung complaint. And within 3 calendar days during which they are in session, i-refer ka agad sa committee. In which case, valid lahat yun. That is a valid way of initiating a complaint. So, hindi problema yun. Doon sa committee naman, they have 60 days, session days, calendar days during which they are in session to finish the hearing and make the report. So, 60 days, 60 calendar days. Sapat na yun eh. Okay lang.
Speaking of test case, it is possible that we're going to get 2 impeachment complaints against the president and the vice president. How do you think that would go? I mean, you as a framer of the Constitution, that will also be tested. That will also test, I guess, the principal function of government. Magiging tried po yung top 2 officials of the land. What are your thoughts on that and the stability of Philippine governance?
Yes, kaya po nilimit ng ating saligang batas yung frequency ng pag-initiate ng impeachment proceedings laban sa high officials is in order not to take them away too much from their primary duty as government officials. Kaya maaari po nung sabay mayroong pinahil na impeachment complaint against both the President and Vice President. It's up to Congress, the lower house, o how to prioritize kung sinong unahin nila dito. That is up to them. However, it is subject to the timeframes under the Constitution. They have to resolve, the committee has to resolve the complaint, make the report within 60 session days. Ang ibig sabihin ngayon ng session days, calendar days during which Congress is in session. So, merong limit eh. They have to act within those 60 days. File the report to the plenary together with the resolution, draft resolution of the articles, or draft resolution denying the complaint.
I guess as a final point, beyond all the legal jargon, do you think that it is now much more complex and difficult to actually use impeachment as an accountability tool?
Under the original decision of the Supreme Court, bago ginawa itong resolution kahapon, it is very difficult because it requires that each and every member of the lower house be proven to have read and understood the complaint, to have studied and understood the evidence. Tinanggal ho yun. Wala na ho yung requirement na yun. In fact, if the Congress, if the lower house adopts the second mode of filing a complaint, that is a verified complaint is signed by at least 1/3 of the members of the House. Dati sinabi, kailangan magkaroon ng hearing yung buong mababang kamara. Ngayon hindi na. Hearing will be by the committee only if Congress wants. Naging optional na yung hearing. So mas madali na rin.
Okay.
Hindi na imposible.
Okay. Maraming salamat. Thank you so much for helping us understand the latest Supreme Court decision. We have the author of Forthwith in the Constitution, retired Associate Justice Adolfo Azcuna Jr.
Thank you, Gretchen.